Start. The law asks whether an ordinary person would take offense to the disclosure of particular private facts. In taking offense, the audience should be exhibiting the general beliefs of the community in which the disclosure takes place. The law recognizes that complete privacy does not exist in modern society. Occasionally, unintentional disclosures of private facts will necessarily occur. Thus, the idea behind the offensiveness element is to restrict actionable claims to disclosures that are particularly harmful. We are connected with the question whether the Central Information Commissioner was right in denying information regarding the third respondent's personal matters pertaining to his service career, and it was on the ground that the information sought for was qualified to be personal information as defined under the Right to Information Act. The question for consideration is whether the aforesaid information sought by the appellant can be treated as personal information. It may be pertinent to mention that this issue came up before the full bench of the Commission, and the Commission held that the income tax return has been rightly held to be personal information which is exempted from disclosure. Any person can deny the disclosure of information because the disclosure of which would endanger the life or physical safety of any person or identify the source of information or assistance given in confidence for law enforcement or security purposes. It also includes the information which relates to personal information and the disclosure of which has no relationship to any public activity or interest, or which would cause unwarranted invasion of the privacy of the individual unless the central public information officer or the state public information officer is satisfied that the large public interest justifies the disclosure of such information. We are in agreement with the CIC and the courts below that the details called for by the petitioner are qualified to be personal information, and they were copies of all memos issued to the third respondent, show cause notices, and orders of censure or punishment, etc. The performance of an employee in an organization is primarily a matter between the employee and the employer, and normally those aspects are governed by the service rules which fall under the expression personal information. Of course, in a given case, if the central public information officer or the state public information officer is satisfied that the larger public interest justifies the disclosure of such information, appropriate orders could be passed, but the petitioner cannot claim those details as a matter of right. There shall be no obligation to give information to any citizen which is in fiduciary relationship unless the competent authority is satisfied. Further, he has also sought for the details of gifts stated to have accepted by the third respondent, his family members, friends, and relatives at the marriage of his son. The information mostly sought for finds a place in the ITRs of the third respondent. You have sought the details of every salary in respect of Shri A.P. Jaiswal, which relates to personal information and the disclosure of which has no relationship to any public activity or interest, and it would cause unwarranted invasion of the privacy of individual. He is working at the post of Provident Fund Commissioner. Hence, it has been denied as per the RTI provision under Section 8 of the Act. We are therefore of the view that the petitioner has not succeeded in establishing that the information sought for is for the larger public interest. That being the fact, we are not inclined to entertain this kind of petition. Stop.
Online software demo coming soon. Stay tuned.